All right, guys, welcome to. We took a month off, so welcome back to Fineworks Live Discussions. We got a great one that everybody has asked a whole lot about, which has been copyright. And we have our guest, David Fox, is going to go ahead and give you more information on that. James has got a few announcements. There's a great sale on a brand new mounting style to our metal that's come out. This is going to give you really nice, clean, really, I want to say, presentation worthy kind of mounting system for your metal prints. I'm going to let James talk a little bit about that sale and about a few things that we have new coming to Finer Works.
Sure. Well, thanks, Melissa, and welcome, David. So, just real quick, right now we have our a new mounting option for the HD metal prints. Uh, uh, HD metal or Chromlux metal prints, as many of y'all know it, are prints sublimated to metal, and they really kind of give a nice, sleek, modern look. Uh, People are always asking us about different ways to display it, and we have a number of mounting options. But something that I saw with a competitor that I thought, hey, we can do that as well, is to offer something called a flush mounted metal print, where the metal is mounted on quarter-inch PVC. Now, where we go one step further is because of the equipment and so forth, we're able to digitally cut these to precision and do all custom sizes and do them up to 30 by 40, whereas this competitor is only able to do smaller ones. It looks great. Wish I had a sample that I could show you, but actually, if you go to our website, the photo kind of shows you, and we route out these keyholes so it's very easy to hang these panels on the wall, and I think people will really like these and the display that they provide. Um, and then the other thing that we have, and I thought I had my sample here, but I guess I don't. I apologize. Is our new hanging canvases. Melissa, if you could kind of go to the canvas page, um, scroll down, the new hanging canvases, kind of like a tapestry. It hangs. There you can do up to 12 inches wide by I believe 36 inches long. So you'll select the custom size when you order those. Right now we just have black. However, as a kind of a wood grain black as an option, but we do have white and a natural wood grain coming within the next few weeks for people to order. And we'll also be ordering the hangers by themselves as a kit, or I'm sorry, by the case. So if that's something that you're interested in ordering, those will be available. And then finally, and this was going to correlate with uh, what we'll be discussing today, is Finerworks is going to be offering a new service. We plan on launching this week, which will be a copyright registration service in concert with DHF Law, um, uh, David's law firm, um, which will allow our users to officially, with the U.S. Copyright uh, Office, register their works of art, and so it'll be officially registered. You'll have official copyright registry, and they even go into a little bit more detail using the. I'm not a lawyer, so I'll let David kind of explain that and a little, provide a few more details on that. But we will announce how to go about doing that and all the details and costs involved later
In
after
our
it.
newsletter, we'll have that out.
What was that? I'm sorry.
We'll have the newsletter go out with
Yeah,
the
the newsletter will go
introduction.
into once we finalize some of the details with David, which we've been working with on this, once we've kind of everything is all the I's are dotted and T's are crossed, we'll be announcing that in our newsletter later this week.
And you can sign up online right now if you go to the bottom of our website right there and put that in. We also have a sale that is ending tomorrow at midnight. Is that correct, James? For that?
Yes, for these flush mount metal prints. And so that's all I have. I'm really looking forward to hearing about copyright. Now, I say I'm looking forward, and some people's like, well, that's not a very interesting topic. And yeah, maybe it doesn't sound the most exciting, but like I told David and Melissa earlier, it's a very important topic for artists. And I think David is going to kind of open our eyes about some things some assumptions that we may have had as artists when it comes to copyright law. And I don't know that I don't know if many artists that have maybe have gone to graphic design school or gotten it, received a fine arts degree. I've heard this is that not all schools really devote as much attention to the importance of copyright that maybe they should. And so I learned something a few months ago, just casually speaking with David about it that I wasn't aware of. And I don't know, David, if you were aware that you educated me on something as basic that I thought as basic as copyright was as basic as copyright, but you did. So anyway, I'm going to shut up and I'm going to let. Matter of fact, I'm going to mute my mic. So I don't keep talking.
Well, yeah, this topic is something that's commonly requested. So for those of you watching live, if you want to, in the comments right now, because you can go ahead and you're going to be able to kind of, in time, participate in this conversation. So in the comments section, whether you're watching on Facebook or whether you're watching on YouTube, if you'll go in there and put where you're watching from, just let us know if you're here from San Antonio or where in the world you are. We'll like to see those comments. I'm going to get ready to introduce David here, and I'm going to have him tell him a little bit about himself, and then we'll get into this presentation because there's just so much in the news with copyright right now. Me and David have talked about the Warhol Foundation's loss of their in their lawsuit for the Prince photo. There has been, I know Disney is getting ready to lose their copyright from that copyright extension from Congress. Just on Mickey Mouse, which is so weird to think of Mickey Mouse in the public domain. But again, what does all of that mean? Because all of us read headlines, and that's about as far as we get in our research, especially when you're doing social media. So with that, I'm going to go ahead and let David kind of just talk about himself here for a second.
Yeah, well, thanks. And thanks for having me. First of all, nobody has to be excited about copyright, because I'm excited for you. There's a lot of areas of law that are very boring. There are people who find tax law exciting, and God bless them, because I could never do that. And I'm sure a lot of people might think the same about copyright law. I think it's exciting. I'm going to go through a presentation, and probably the most important thing that you don't learn in an art school, in any sort of creative degree, is the realities of theft and infringement and how to handle that when it happens. But I'll get into that a little bit later. My road to becoming a lawyer was rather circuitous. I started out as a car mechanic for U-Haul right out of college. And then I worked for a music magazine for several years in the Northwest. And then from the music magazine, I thought, I could make more money and do publicity, because the press releases I'm getting from all these music companies aren't really cutting it. and I can do better. And I think I did. But anyway, I left that to pursue a career in academia, to get a degree actually in religious studies and studying non-institutional religion. But the academic world didn't really appeal to me. And I'll talk more about that if people want to know why. But I eventually went to law school. It had the same sort of writing and research activities that I really enjoyed with academia, but it was a more straightforward way to make a living. And I tried to pigeonhole myself as an intellectual property attorney while I was in law school, taking all their copyright and trademark courses and survey courses that I could. And all the externships that I did during law school were for volunteer lawyers for the arts, the Dramatists Guild, trade associations. And I was warned by my student advisor not to pigeonhole myself. And I said, I came back to law school late. At this point in life, I want to pigeonhole myself and sort of do the career that I decided I wanted to do. Out of law school, my first job was as an environmental lawyer. It was the best offer that I got. And that sounds really cool. It sounded cool to a lot of my friends in the Northwest. Oh, that's really cool. You're an environmental lawyer. But then I'd have to break the news to them that I wasn't practicing law on the side of the environment. So each day that went by, I could look myself in the mirror a little bit less. But I always kept a foot in the intellectual property world. And eventually I got a job as the director of business affairs at the Dramatists Guild, and they allowed me to run a private practice as well. So with my private practice, I had one client that was a fashion client, but from there I built a practice around using theater and fashion as my foundation, and then into photography and painters. And I don't do a lot of music. I will do some music law, but I'm not a specialist in music law. So that's how I came to be where I am today. That was about 2 decades ago. But my circuitous path, my involvement with the music industry and even in academia kind of informed me. It got my hands dirty in the business end of the music industry, and even in the business end of publishing. When you're trying to publish something as an academic, I have people who come to me with textbooks, and sometimes the textbooks have illustrations, sometimes the textbooks are about fine arts. And I know what the pressures are with the college saying that they want to own the copyright, but they're mistaken. A tenured professor certainly would own their own copyright. You own the copyright in your dissertation. So that's where I'm at today. And I do have a presentation that I can make with the caveat that I'm happy to take questions at any time. When I do a talk like this, it's hard to tell, I go off of what are the most common pieces of information that I find myself telling clients or potential clients. And so I developed this presentation around that. But this is a whole new crowd. These are people I've never met before. So whatever questions you have, I'm happy to answer them. And Melissa, I guess you'll let me know if anybody raises their hand.
Yeah, well, we already have one, but what I'll do is let me let you dive a little into your presentation, and we'll get this started, because this is something I've heard commonly, which is social media and copyright. So we'll get that towards the end, and I'll let you dive into your presentation.
Yeah, that sounds good. All right. So in this presentation, the order of things is I was going to go over copyright, then I was going to go over gallery contracts, some of the common things that you would negotiate, and then go into fair use. It's from the simplest to the most complex. Copyright is, you have a copyright as soon as you've have an original expression fixed in tangible form. So it has to be an original expression. It can't be, a stick figure. It can't be, a sentence like, JFK was assassinated in November. That's you can't submit that to the Copyright Office and then demand that nobody can use a stick figure because you own the copyright in stick figures. Nobody can use this sentence about JFK because you own that. You have to get a nickel every time somebody uses those things. So it has to be original. And it has to be fixed in tangible form. And I wonder if anybody in the comment section wants to venture a guess as to why it has to be fixed in tangible form.
We'll give people a second there to type in.
Yeah.
Anybody have a guess?
I don't know how interactive this crew is.
Well, we got some questions. I don't know if anything. Oh, we have.
Okay. Well, I'll tell you. It's because if it's not fixed in tangible form, it's unlikely that you'll be able to enforce that copyright. People need to know what you're claiming. So if you made a painting and somebody copied that painting and you accuse them, hey, you copied my painting, and so you have to stop and you should probably pay me for damages or disgorge I should disgorge you of whatever profits you made off of that painting that you copied on me. They have every right to turn around and say, wait a second, what did I copy? What I need to look at what you're talking about to know, so that I know that I copied it. If there's a coincidence where two people did the same painting, then there's a question in copyright law so someone went up and said proof. You need to be able to prove that the thing that you claim is yours, what it looks like in detail.
David, may I ask a real quick question? Now, when you say tangible form, tangible does not necessarily have to mean a physical form, because obviously a digital photo is not it not exactly a physical item like a painting, but it's
right.
It's tangible.
Yeah. So in law school, we the big borderline questions are: is a sandcastle copyrightable? Is if you write a poem on the frost of a cabin window, is that copyrightable? Because those are ephemeral to some extent. Well, how ephemeral can they be before they're not in tangible form anymore? And the definition of tangible form is actually that it's perceivable by the senses. So when you're talking about digital work, it's perceivable. It might be broken down into code, but it's something that can be repeatable and shown to other people. And if you look back here, the other thing that I said was it's an original expression. It's an expression. So if I say that that April's awful, that's one way of saying it. But if I want to express that idea and say that April is the cruelest month, like the famous poet, like T.S. Eliot said, then I'm getting closer to that expression. So you can't copy ideas or facts. And this is especially important if you work with creative groups and you tell someone the idea for your painting, and then they do a painting of that idea, then you can't really go to a lawyer and say they took my idea. Well, the idea was free. It's the expression of that idea. Chances are, if I threw out an idea for a painting right now and chose 12 people from our audience and said, come back to me next week with a painting of this, all 12 people would come back with 12 different paintings, 12 different expressions. So it's not the idea that you're sort of surrounding and protecting as your own. It's the expression of that idea. This point is really important. This is to me is when copyright starts getting interesting. It's for your lifetime plus 70 years. And I know that when all of us start out young, we don't really think about the next generation or anything. But as soon as you have a kid, you start to realize this these paintings are going to be my legacy, my part of my estate. And when you're making contracts, you're not just making a contract for yourself, you're really making a contract for yourself and all of your heirs. Even if they're not bloodline heirs, whoever's going to get those paintings afterwards, they're going to be affected by whatever contracts that you sign. So if you're giving a gallery 50%, or if you say to somebody, oh, you really helped me work through this piece of art and advised me, sort of like a dramaturg might in the theater for a director, for an author, you really helped me sort of form my ideas, then why don't I give you 5% of whatever I get after this? That's a very dangerous game, and those percentages start to add up, and they're going to last 70 years after you're dead and gone. Now, when you're licensing rights to your copyright, there are these 5 basic bundle of rights: reproduction, distribution. Reproduction and distribution combined is what we call publication. That's all publication is. It's those 2 rights combined into one word. Display is what you see commonly with works of visual art. They have the right to display it. And importantly, with the display right, when you sell a painting, you're not selling the copyright in the painting. At least you shouldn't be. There should be nothing in a contract or a purchase agreement that says that the copyright goes with the physical painting. You're selling your patron the physical artwork and the right to display it. You're not selling the copyright in it. So, for example, if you sell a painting and the buyer decides to make little postcards out of that painting, that would almost certainly be an infringement of your right. You say, wait, there was nothing in there about reproduction and distribution. All we were talking about was you get to have the painting, you get to put it in your private study, you get to put it in your attic, you get to put it in your living room, but and you might lend it to a museum to show, or lend it to somebody else to show, but you don't own the copyright in it. You can't make these other works, these postcards and such. That would be a derivative work, and that's a separate right. Live performance doesn't really apply as much here today, but that's obviously for plays. And then derivative works, that might be, we'll see in the fair use section of this talk, what we can consider a derivative work versus a transformative work or something like that. But a derivative work might be something like a variation that doesn't give any new meaning or anything to your play. It would be like postcards of your painting. So those are the 5 works. I see Dominion's statement there.
Yeah.
We'll get to that.
Yeah.
The benefits of copyright registration. So you have those rights. These rights that I showed you, you have them as soon as you fix your original expression in tangible form. You have these rights. These are yours. But you can't enforce those rights until you register your work. And sorry about the N being cut off at the end there. That's likely my fault. But it is registration. It's not registratio. But you get with a registration, you get the keys to the courthouse. So if somebody infringes your work, if they are selling postcards without your authorization, or if they just took your work, or if they just did forgery essentially of your work, and you want to sue them, then the first thing that the judge will ask is, what's the registration number? And if there's no registration number, then the judge will say, all right, I'm going to dismiss this case without prejudice, meaning you can refile this case. But before you refile it, you're going to have to register it with the Copyright Office, and I want to see a registration number. You can't sue without a copyright registration. I don't care if you mailed something to yourself. I don't care if you filed with some trade association or, a common thing we see in Hollywood is the Writers Guild Association has a registry of scripts, and they say, oh, for X amount of dollars, $75, you can register your script with us. It might even be cheaper, because I think it's cheaper than doing a copyright with the Copyright Office. So people will register their work with the WGA, the Writers Guild of America, but it doesn't do anything. It does nothing. It doesn't get you into the courthouse. It doesn't get you any benefits. So what are the benefits? You've got, if you can file for registration prior to an infringement, preferably either before publication or within 3 months of publication, then you can request attorney's fees and you can request statutory damages. Statutory damages are important because if somebody takes your work, the first thing they might say is, how are you damaged? Nobody knew who you were except for when I took your work and put it out there and sold it. You never would have sold it. So if they sell your work for $500, that doesn't mean you're damaged $500. So you have to go out and try to prove these damages, and you have to hire your lawyers to argue these damages. Or if you register in time, you can claim statutory damages. Much easier. Statutory damages are from $500 to $150,000 per infringement. And now you're convincing the court, where between $500 and $150,000, Your Honor, do you think that this infringement is worth, especially considering how willful the infringement was and how much the person did in the infringement, how much marketing they did, for example. And if you file registration within 5 years of publication, you get a prima facie proof of a valid copyright, meaning the court's going to presume that the copyright's valid. So instead of you walking into court and having to prove that you have a valid copyright, if that's any question at all, it's the other side and the other side's lawyers that are charging their billable hours that are going to have to prove that you don't have a valid copyright. So as soon as you have a registration, it's pretty much accepted that you have a valid copyright in most instances.
So what you're telling me is the burden of proof, or what you're telling everyone is the burden of, when you have a registered copyright, pretty much automatically the burden of proof lies on the defendant at that point.
That's right. The burden of proof costs money. If you have to prove things, you have to do research, or your lawyers have to do research, and your lawyers have to do depositions. And if you have the registration, then the other guy has to do that. And so it's more expensive for the defendant, for the infringer, to withstand a lawsuit than it is for you. And should you register before you post online? 100% yes. Posting online is a publication. It's making the work public. And yeah, so that's, you're really going to want to register either before you post something online, or really have your act together and try to get it registered within 3 months. Try to submit that registration within 3 months of publication. Now, the Copyright Office, their process is about 3.1 months. Last time I looked, which was a couple days ago, to process an application into a registration. But I've seen it take up to 8 months. And if the specialist at the government is finds something that they have a question about, it can be extended, up to a year. It can be difficult. I got an email today from someone who said that, that it's going on 10 months, I think. And the specialist at the government said, we don't think this application, you haven't answered all our questions yet about this application. And he's like, I did answer the question. He's like, oh, well, it's still in process. It's 10 months later. Now, assuming that registration issues, the protection starts back when you initially submitted the application. But still, you have this weird gray area that can be very vexing. So you want to get on that as soon as possible. Are there any questions about copyright in general? Because I'm going to move on to the gallery contracts pretty soon.
Let's see. I know we have a few questions on here. Let's see, how to protect one's work online. And I see his thing because, for artists, especially with social media nowadays, the work in progress post, like with outlets like TikTok, where you're trying to do it, or live streaming, where people are doing their work, and they post these photos on, because they're trying to sell, get that image everywhere. That kind of, is there any protection when you're doing that, from the image being, to go back and tell people not to be able to reuse it? Just in this instance, he's putting a watermark signature with copyright year on the work. But if you're somebody who has not yet copyrighted this because you're just creating it, how do you protect it when you're trying to promote it online?
The whole work in progress thing, I just jotted down works in progress because I think it deserves an article of its own. It's a nightmare. It's obviously not registered. So if somebody infringes your work, you won't get the statutory benefits if you haven't registered for copyright, and you're posting things on a work in progress. The best I can say is, time delay the work in progress videos so that you have the finished work, you send it in, and then once a day you post these works in progress. But I know it's not in the spirit of the thing, of what you're trying to accomplish and the excitement you're trying to generate. Mm-hmm. But from a legal perspective, it's nightmarish. So they're not protected. You can go after somebody, you just can't get those statutory benefits. And if somebody copies your work that you've posted as a work in progress, you have to quickly register it. And what I would do in that situation, if someone called me in that situation, I would say, all right, let's register it, and I'll write a cease and desist letter. It won't have a registration number on it, but as soon as we file it, we'll have a tracking number that will indicate to most lawyers this. Like, I can look at the number and I'll say, oh, that's a tracking number. That means the registration hasn't issued yet, but they've applied for it. Mm-hmm. So they might not be able to sue me today, but in a couple of months, they'll be able to go to court.
That's a good idea.
Yeah. And before we ask, Yvette has a question. Just real quick, will we know when an item has finished the process of being going through the Copyright Office? Do they send a notification to the artist, or do they get a letter in the mail, some sort of proof or registration number that they can easily reference? Because I know you said it, 3-10 months, whatever,
right.
the time frame is, and maybe that changes by next year, but still, at some point they're going to have some sort of proof or better. And how is that presented to the artist?
Well, ultimately, when registration issues, they send you a nice registration certificate on thick paper with a nice gold stamp on it. Okay. And it has the registration number on it. Now there's a little bit of lag time when registration is issued. And if you can go to copyright.gov and keep putting your name in their database of registrations. And if it comes up, you have the registration number. You don't need the certificate. You should have the certificate if you're going to go to court, but all you really need is the registration number. If the Copyright Office is still in process, it's going to be almost impossible to get information about it. It's really a up or down vote on what's going on with your copyright until it finally registers. The people at the Copyright Office are overworked and underpaid, and I think it would be too much to ask that they respond to every single phone call or email they get asking about their copyright, although they will get back to you eventually. But you might as well just wait for the copyright. If something hasn't happened after 3 or 4 months, you should call the copyright office and check up on it. But they'll almost invariably say it's still in process. So this question about artificial intelligence.
Yeah, because artificial intelligence, one of the big, I want to say, pushbacks from artists has been that these AI databases are kind of being populated by images that kind of, I guess, like the way a web spider would kind of crawl across the internet and pick images. So it can use things from Instagram. It can use images. So it's using an artist's work to compile another.
Right, to learn.
Yeah, to learn. But it some of that work gets kind of in there because, again, this is a new technology that's kind of here on the rise. And so how do artists protect their art from being utilized in an AI software?
Well, technology is going faster than the government. Big surprise, right? But if something's generated entirely by artificial intelligence, it's not copyrightable. If the author was unable to bleed, then they're not going to be able to get copyright protection. If nuts and bolts can't get copyright protection. Well, even the monkey that took the selfie didn't get copyright protection because the monkey's not human. It has to be a human being. Now, in terms of the intake of copyrighted works, that's part of a big argument, and the Copyright Office is actually holding sessions to hear from leaders and various trade associations. Graphic artists have a number of associations that they can rely on, and there's some rather diligent in-house counsel there who are discussing this. They're talking about the possibility of robot text to opt out of being scanned by AI, so that your works would not be sort of ingested by the AI program. But that's still up in the air. It's still up in the air as to what to do about it. And people even argue about that. They say, well, these opt-out programs aren't very good. And other people say, no, they are very good. There's no case law as of yet.
Yeah. I think we had a question too on NFTs there. Let's see, what about NFTs? Also about the copyrights and use protection. That's another thing with the digital art with NFTs. How is copyright lent in that realm?
Well, NFTs are really decided by the contract, and the contract is put into code into the blockchain. So my job as an intellectual property attorney would be to go to the programmers, the people building the NFT, to say, here's a checklist of the things that have to be in the blockchain. It can't be sold, or if it's sold, the artist gets 10%. It can't be derivative works. It can only be display, and it can only be display digitally. It can't be printed out. Whatever the restrictions are, that's the checklist, and you have the programmers essentially sign a sworn statement saying that these things are in the coding. I don't know how the life of NFTs is going to survive, because every time you come up with a protection, someone will come up with a hack, and then you come up with a protection to that, and then somebody comes up with a hack to that. It's going to be interesting.
Let's see, we got Jalen here. How does copyright work with an artist whose artwork uses a lot of appropriation, collage, images from magazines, using found photographs, images? is the artist infringing on other people's copyrights?
That's a fair use question.
Okay, so
Should I skip to the fair use section since that question was asked?
we'll circle back then to this question.
Okay.
Okay, because you're going to cover that. Let's see what else we have in here. I think Yvette had another question. Do chats and emails count as publication? Meaning if you send a photo of your image in a text, Instagram or email, is this considered publication?
Yeah, I mean, you should assume it is. There's a practical consideration to that. So if you send it out to somebody, if you send it out to your best friend and say don't show it to anybody, and you trust your best friend, and your best friend's trustworthy, maybe that's more of a private viewing, right?
Mm-hmm.
It hasn't been made public per se. But if you put it on Instagram, or you could certainly. Well, let me put it this way. You want to try to register things before publication or within 3 months of publication. So if you send something if you sent 2 images out via text, or if you sent the same image out to 2 different people via text, you could claim that's publication, but it might be to your advantage to characterize that as a private viewing and not yet made public. But people could argue that it was made public at that time and it was therefore a publication. So you do have to be careful about it.
So that's different than I remember back in the day with musician friends about or poetry, writing the stuff down and mailing it to yourself. Is that kind of what the email comes down to and the private chats?
Well, it doesn't get you in the courthouse. Usually people emailed things to themselves thinking that was a legitimate form of copyright, but it doesn't have the registration number. You don't get the statutory benefits. That used to be called poor man's copyright.
Yeah, I remember that.
Yeah.
See. We have one other question in here. What happens with the fact that other countries may have different copyright laws and online is global? How can it be protected with those in other countries that may infringe? And I think we had been talking about that Mobius case on it for counterfeit art also being made of his, like Audrey Hepburn with the bubble gum or Marilyn Monroe with the bubble gum. So, how do you protect yourselves from global laws or different municipality laws around the world?
Well, there are some countries where it might be more effective to hire a big guy with a baseball bat than a lawyer. But most countries these days belong to what's called the Berne Convention. And that means that if your work is infringed in the UK, we're both members of the Berne Convention, so U.S. authors get U.S. protection of their works, even if their works are being infringed in the UK, and vice versa. So as long as it's a Berne Convention country, then you should be able to do something. But again, to be practical, you still might be talking about hiring people in that foreign country to track the person down and make them pay, make them at least respond.
Where would jurisdiction of those cases lie? Within where the country the offense occurred, or where the copyright is registered?
Well, if I have a painting and it gets infringed in the UK, I would sue the person in the Southern District of New York, or in Pennsylvania, wherever I'm residing at the moment. I would sue them in the federal court where I am. If for some weird reason the courts agree that the venue should be moved to the UK, and it might be moved there because that's where all the witnesses of the infringement are. That's where the infringement took place. That's where all the documentation is. So it's more practical for me to sue my infringer in the UK, and that's what the court says. If for some reason that happens, that UK court is still under obligation under the Berne Convention to apply US law. All right. Should we move on to gallery contracts?
Let's go ahead and move
What's
on. We got a lot of questions still. We have a lot of questions, but we'll save some towards the end. I think, like I said, you're going to kind of cover some of these questions in your presentation going forward. So I'll go ahead and do some more questions getting closer to the end.
Yeah, and we'll, I'll go through the gallery stuff pretty quick. I'll gauge the interest to that. I might move really quick through that. But with gallery contracts, you have the scope of rights of what you're allowing the gallerist of your work, and it's usually one painting or the paintings in a specific exhibition. You have special situations like Cy Twombly was always going to show his works in the Gagosian in New York. You have special relationships like that. I think Damien Hirst has his collection of galleries that he is exclusive to in various countries. But usually, especially when you're just starting out, you don't want to give away the farm because you don't know how it's going to affect you in the future. You don't know how it's going to affect your heirs. So you start off with one painting, try it out, let the relationship develop from there. When you're delivering the works, who pays for the transport? Who pays for the insurance on the art? Now, I mostly represent artists, so I'm always of a mind that the gallery should be able to pay for the insurance. The gallery would prefer that the artist pay for transportation and insurance. Usually where it ends up is that the gallery, the artist might get the works there, and then the gallery would pay for the transport and insurance to get them back to the artist. That way, at least the gallerist has this additional little incentive to sell the works and not have to deal with that problem. If the gallerist sells all your works, then the gallerist doesn't have to pay for any insurance or transportation after that. With pricing, I've dealt with a lot of galleries that they say there are certain people who, when they walk in the door, I know they buy so much art from me, I'm giving them a 50% discount right off the top. So keep that in mind when you're pricing your paintings. A lot of paintings will go for what, $80 to $800 for beginning artists, and so you might get $400 or $40 to $400. But obviously, as an artist's attorney, I try to drive that percentage down. With completed sales, the gallery wants to pay when it receives full payment. So if a buyer is saying, "Oh, I'm buying this painting for $1,000, I'll pay you $500 now and $500 later," the gallerist wants to pay you your cut when they've received the full 1,000. But most artists want to get paid as the funds are received. So pay me my cut when you get the first 500 and my cut when you get the second 500. Because, you might have to buy groceries, pay an electric bill. But that begs the question of how much should an artist get? You should get 50%. See if you can increase this, of course. It depends. This depends exclusively on the leverage of the artist, the relationship the artist and the gallerist have, and on the leverage of the gallerist. If you're getting if you're getting in a gallery that is really well known, then you might be likely to be happy with that 50%. Of course, there are galleries out there that'll try to overreach and go and take more than 50% for themselves, but
The 60-40 split.
60-40 split.
Yeah.
Yeah. Well, they like to tell the board of directors that they're maximizing the income.
Yeah.
You want your paintings to be with that gallery, either for the specific showing, but 2 to 5 years is the typical relationship with the gallery. And the gallery should return all works at the end of that term, whatever you negotiate. And then there might be this little gray area. If somebody walks into the gallery and says, "Oh, how much is that painting?" and then walks out without buying it, I don't think a substantial negotiation has taken place. That gallery should probably return the painting if the term has ended, and let the artist and the patron work out a price for themselves. But artist is always the beneficiary on the insurance, by the way.
Yeah.
So that's substantial negotiation. So that was gallery contracts. Did I go through that quick enough?
Yeah, and I've worked in a gallery, and some galleries, I'm glad the galleries I've worked have not enforced this, but in some contracts they have had a 100-mile kind of radius where basically that artist cannot show any of their artworks within, X amount of miles radius. What are your thoughts on that? Should artists get into those kind of contracts where they now are, especially if it's in their home city? Does that do more of a disadvantage in contracts that you've seen?
I don't think so. I mean, it's fair as long as it's fair to the gallery. The gallery has a legitimate concern at being the exclusive place where it can see your work. You might see contracts where they say we're exclusive for the United States of America. And I, as a lawyer, would say, can you show me proof of how your influence extends from, Alaska to Florida? And because if it does, fair enough, we'll give you United States. You rarely see worldwide unless, it is like a Gagosian or some major dealer. Most of the time, though, it is city or statewide, or 100-mile radius, 75-mile radius. And I think those are fair. I think if there's any questions about that, about the geographic exclusivity, you can certainly have an honest and straightforward conversation with the gallery to say, look, I'm here in San Antonio, but I'm also showing in Santa Fe. Mm-hmm. I don't know how far away Santa Fe is from San Antonio, but I imagine it's more than 100 miles.
It takes forever to get out of Texas. So
right. You pull over and cry halfway.
Yeah, pretty much. I've made the drive to LA. It's a long time before you get to
LA.
So.
Yeah. So, you might, you should be able to have carve outs like that. If you have genuine plans, as long as you're not being frivolous about it, to say, I only want a 10-mile radius because I'm going to go to your competitor that's 11 miles away. But the competitor, you haven't even talked to the competitor yet. That would be considered bad faith negotiation, or, something you wouldn't want to get a reputation for.
Yeah, well, let's go ahead and plow on forward, because I'd like to get to some of the questions at the end of your presentation.
Yeah. Fair use is, you can't quite see that there are 4 elements there, but there's nature of use, which is the use by the fair user, the person who comes along and uses it. Is the use commercial or nonprofit? Is the use creative or non-creative? The nature of the underlying work is the second factor. And that's pretty much, are you copying a phone book or a scientific taxonomy of butterflies in alphabetical order, or are you copying a poem or a painting? The amount of use is how much of the work are you using. You should only be using as a fair user, you should only be using the amount of work necessary. You shouldn't use 99% of the work because you wanted to make this comment that was found in 5% of the work. if you want to think about amount of use, that can be a tricky one. If in music, for example, you'll hear, oh, I heard you can use up to 5 seconds or up to 3 seconds. There's all these weird rumors around. There's nothing in the law about that. But I heard you can use up to 3 seconds of a work without having, and that'll automatically be considered fair use. It won't be infringement. But chances are, if you're taking from another work, you're taking the hook of that work. So it might be da 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 da, and sooner or later, someone's going to say, "Oh, that's the hook from Mr. Big Stuff." I'm a little older. My references are older, so hopefully people know what that song is. But everyone's heard a hook that is less than 3 seconds. So the amount of use can be both qualitative and quantitative. So minimal qualitative use would be using that hook of a song, or it might be using. I guarantee that if I made a painting that used just a little bit of one of Dali's paintings, most people on this stream would be able to point to that and say he got that from a Dali painting. So then it becomes a question of the other factors in there, and was the amount of use the least that I could have used, assuming that Dali painting was still under copyright for some reason, and then the effect on the market for the underlying work owner. So if you're copying my work and licensing it to the same people that I'm licensing it to, or in the instance of the Harry Potter books, somebody made an encyclopedia of a lot of the Harry Potter terms that were in there, but the publishers of Harry Potter were already working on their own encyclopedia, so it was going to undermine their work on that work, on that avenue of exploiting Harry Potter. So that's about as brief a review of fair use I can get. And I know we were talking about the Melissa, you and I talked a little bit about Andy Warhol Foundation versus Goldsmith, and this is a testament to how difficult it can be to do a fair use analysis. So I get a lot of people, including collage artists, who say, I'm taking these pictures from these magazines from the 1950s and 60s, and I'm using them in my collage art. Can you tell me if that's fair use? And it's like, well, that's pretty troubling. I would have to figure out who the photographer was, if the photographer had sufficient notoriety to be able to keep their copyright, or if the magazine owned the copyright, like it would in most instances. And I'd have to figure out if the work was properly registered with the Copyright Office. And because this is before 1978, I would have to figure out if it was properly renewed with the Copyright Office. And that's a lot of work to research. There's not a lot of clearinghouses out there that I can just dive into and put in a couple of keywords and get that done. That represents hours of work. And for me to say that something is fair use or is not fair use, there's liability there for the lawyer. If I tell a collage artist, this is fair use, go ahead and use it, and they get sued and they lose the lawsuit, that's a problem for the lawyer who said that it was fair use. So there has to be a rationale behind it. There has to be research behind it. And the Andy Warhol case is, it sort of digs up some of those issues. In that case, they were only talking about the first factor, the nature of the use. And whether the work was derivative or transformative. Now, if you remember, a derivative work you have to license. That's one of the rights of an artist. That's one of the 5 bundle of rights is the right to make a derivative work. But if it's transformative, then there is no license. This is because copyright Copyright is essentially taking things out of the public domain and saying they're mine, mine, all mine. You can't use them without my authorization. So that's a problem because people have free speech. So what do you do about that? Well, you give them a limited copyright. You give them a limited monopoly over that image, over that text. But there has to be sort of a safety valve to critique and comment and talk about that text or that image. So that's where fair use comes in. And if you can transform it, that means that you've added new meaning or expression to the original work. And this is all under the first factor. What's the nature of the use of the person who's claiming fair use? So the question that the court asked in that case was whether and to what extent the use at issue has a purpose or character different from the original. And this is Orange Prince, and Orange Prince was based on the portrait. And you can, were they both in there? So you can see them side by side here. We have the portrait on the left, obviously, and you have Orange Prince, which was the subject of the litigation. Actually, that's Purple Prince. That was the initial 1984 derivative work that was authorized by Goldsmith in 1984 for Vanity Fair. And then later came Orange Prince, which was what was published in 2019, I think. 2018. Well, it was soon after Prince's death. So the court said that the degree of transformation has to go beyond that required to qualify as a derivative. So it has to be transformative. It has to, which means more than derivative. And the actual question presented was whether the first fair use factor, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, weighs in favor of AWF's recent licensing to Condé Nast. For those of you who don't know, Goldsmith took this portrait in 1981, the original portrait, when Prince was up and coming, but not the superstar he eventually became. And in 1984, Vanity Fair said, we want to publish your portrait, but we actually want to use your portrait as source material and have Andy Warhol do something with it. And that's when he created Purple Prince. Goldsmith got paid. She said, here, pay me this. You have a one-time authorization to create a work that's based on my work. And she got paid. Mm-hmm. And then flash forward to Prince passes away, and Condé Nast, which owns Vanity Fair, wanted to run a retrospective, an article on Prince. And unbeknownst to Goldsmith and really even to Vanity Fair, Andy Warhol, of course, he can't do one screen print of anything. He has to do 15. And so he had secretly done 15, and they belonged to the Andy Warhol Foundation. And the Andy Warhol Foundation said, sure, Condé Nast, you can license one of our screen prints and just pick which one, and we'll license it to you. And they picked Orange Prince. And Andy Warhol Foundation got paid for it. So Goldsmith and Andy Warhol Foundation ended up in court. The leading case for fair use is Campbell v. Cuff Rose. It's the leading precedent, where the Supreme Court said that if a use is commercial, and in that case, the Roy Orbison song "Oh Pretty Woman" was used by the rap band Two Live Crew, but they used the main lick and some of the lyrics, some of Orbison's singing, but they created a song that was, let's just say, less romantic than the original.
Yeah. Two Live Crew gives it away.
Yeah. So they made that distinction between commercial or nonprofit use, and the first factor relates to the justification for the use. Two Live Crew, the court said this requires the addition of a new expression, meaning, or message, but not just any new meaning, message, or expression. And so what they said in this case with Roy Orbison and Two Live Crew was satire is not fair use, but parody is. So the difference between satire and parody is very important. Parody is when you're making fun, you're using something to comment on it, make fun of it. Satire is when you're using something to make fun of something else over there. So the big satire case is when someone published a book called The Cat in the Hat, and it had all the Dr. Seuss imagery and the meter of Dr. Seuss, but it wasn't about the Cat in the Hat. It was about the O.J. Simpson murders. Well, he was exonerated, but the murders that O.J. Simpson was involved with in court. So that was considered a satire because one artist used Dr. Seuss to comment on O.J. That's satire. But Two Live Crew used Roy Orbison's Pretty Woman to comment on the description of the Pretty Woman, of the image that Roy Orbison was doing. It was a critique. It was a comment. It's something that had to have been fair use, because if you go to an artist and say, hey, I want to make fun of your stuff because I think it's kind of ridiculous. Will you license that to me? Will you give me permission? The answer is probably going to be no. So now you're shutting down someone's free speech, and that's why fair use exists. So the court said that the appearance of the orange print image is substantially the same as that of Goldsmith's original photograph. And you can see that here, that it's essentially the portrait, but it's an orange silk screen. The use is also of a commercial nature in both. Taken together, these two elements counsel against fair use here. So it wasn't different enough from the portrait, and both were of a commercial nature. Goldsmith would have licensed the work to Vanity Fair and gotten paid, but she didn't, because someone took something that wasn't that different and licensed it to Vanity Fair, and they got paid instead. Both were used to illustrate a magazine about Prince with a portrait of Prince. And Orange Prince had no critical bearing on Prince, making this more of a satire than a parody. So that gives you, I don't expect, this court decision leaves more questions than answers. And in fact, the justices went after each other. I've never seen such vitriol between justices in their decisions, particularly Justice Kagan wrote a dissent, and Justice Sotomayor wrote the main decision, and they really went after each other in a way I've never seen in court decisions. But so this decision is going to have to be fleshed out over time with more case law, and that gives you an idea of the problem, how complex fair use is, and why you can't really ask somebody to give you a gut reaction on whether something is fair use or not.
With the, I know sometimes people say they kind of paint on the premise of, just do it and ask for forgiveness later as opposed to ask for permission. The way legalities work, would an artist basically receive a cease and desist order, and they would just have to stop before they would run into, I want to say, punitive kind of that they would actually have to financially be. How does that work? What is the repercussions on an artist if you're infringing and you're, like I said, with your initial intent is not to infringe, but maybe again, parody art, and parody art doesn't leave, because you're trying to stay where that is recognizable still as the artist, the original artist intent, but you're wanting to make fun of it. Where do the, what are the results that that an artist could suffer if they go ahead and do a parody piece?
Well, you see it a lot with photographs where, somebody's dim-witted son-in-law put a picture on your website and they didn't think much of it. They thought, well, it's on the internet, so that means it's public domain, right? And so they take somebody's photograph and they put it on their employer's website. And then the employer gets a cease and desist letter from Higbee and Associates, or one of these so-called copyright troll firms, that says, you have to stop this now. We want to know where you got it. We want to know if you have any other of our images that you're using, and we want $3,000. And if you don't respond to us in a week, it's going to be $6,000. And if you don't respond to us a week after that, it's going to be $12,000. And if you don't respond to us after that, we're going to sue you for $30,000. We're going to take you to court after that for $30,000. So the licensing fees can come up pretty quick. Other things that people do, I know in the theater world, there was a use of there was a play called Whose Holiday, which was about how the Grinch stole Christmas, Cindy Lou Who, but it was her 40 years in the future or 20 years in the future or whatever, and she was pregnant and by the Grinch, and the Grinch was coming back from prison, and they were both drug addicts. But it was Christmas, so it was kind of a Christmas story. And the Dr. Seuss Enterprises, they just wanted that to stop. They just wanted to shut it down. They weren't asking for money, and actually, the director was ignoring the whole problem. So the director just didn't want to deal with it, which I don't really advise. And the author was ignorant to these letters being sent. And so finally, Dr. Seuss Enterprises sent cease and desist letters to the board of the theater, because it was a not-for-profit theater. And you would see that in a not-for-profit gallery. If somebody wanted to shut down a show, the quickest way to do it is contact the people who are on the board and say, you're on the board, you're going to be on the hook for some of this. Mm-hmm. And that's a nice quick way to say, we're just going to shut it down. It's not, I'm a volunteer here, and the last thing I need is liability. So it can go that way too. It can also go the other way with the Andy Warhol Federation versus Goldsmith. Goldsmith initially contacted the Andy Warhol Federation, said, what are you doing? This is my work. We have to talk about this. And the Andy Warhol Foundation said, you know what? We got more. I mean, I'm sort of speculating here. I'm reading minds here. But the Andy Warhol Federation, I assume, thought internally, we've got more money here at the AWF than Goldsmith does. Let's just take her to court, and we'll ask the judge for what's called a declaratory judgment. Your Honor, we want you to declare that this is fair use or otherwise not infringement. So this woman who's an artist reaches out and says, you took my work without authorization. Next thing she knows, she's in court against a behemoth and she's got to hire lawyers. And that went all the way to the Supreme Court. I can't imagine how much that cost her. So yeah, it can start quick, to answer your question, Melissa.
Yeah. Let's see. I think we have,
and we can take down the presentation since I'm done with it. Public domain is anything that was published in the U.S. before 1928. It used to be 1923, but as time goes on, the period for public domain is starting to follow us.
Okay.
You had mentioned something about, I thought I heard you say something about renewing copyright. What exactly is renewing copyright versus registering copyright? How are those?
Well, we can go back to the Statute of Anne, when copyright was first invented for 7 years, and then it was 14 years, then it was 14 years, but if you renew it, it's 20. You can get another 14 years, it'd be 28. And then under the 1909 Act, you would register copyright for 28 years and then be able to renew it for another 28. So you'd have a total of 56 years, but you had to renew it. With 1976
It's-
Copyright Act that started January 1st, 1978, you don't have to renew it. The copyright lasts for your lifetime plus 70 years.
So no one has to worry about that.
Don't worry about renewing it. Renewing it only comes up if you're a collage artist trying to figure out if this piece of work is still in the is still under registration. If you didn't renew it back in the old days, it would fall into the public domain. So it makes a big difference. But that's pre-1978.
Gotcha. Okay, thank you. Yeah.
And we got this one on digital works that are created. And then I know right now with AI, anything AI created is not under protection of copyright, but when it's an original created work, I believe it is, correct?
Oh yeah, and for digital work, you can, if it's a visual work, you can submit the image, which is the smarter way to go. I mean, technically, you could, with some digital works, you might be able to submit the code, but really, you're not protecting the code because people could write other code to come up with the same image. So you want to register the image, and that's usually JPEG.
Now, when you register an image for copyright protection,
Yeah.
you're not the Copyright Office doesn't want you to send them originals or prints or anything physical. They're going to want the artist or the photographer to send some sort of digital format, I'm assuming, at least nowadays, correct?
Yeah, because it's mostly done through the Electronic Copyright Office, the ECO, and you deposit the works at the end of the application process, and it's usually, like I say, in JPEG or maybe TIFF, maybe a couple other formats.
Does it have to be a high quality image, or is there any do they have to get their artwork professionally scanned, or can they just take a photograph from their phone?
It's supposed to be the best copy available.
Okay.
Yeah, it's supposed. I mean, that's the way that the statute is written: the best copy available, and they will take physical copies of anything, but you just have to pay more.
Okay.
Can you register several paintings at a time?
You can register that. The Copyright Office has a couple of options. One is that you can register up to 10 unpublished works as one group. They have to be unpublished, and it has to be the same kind of work, meaning that you can't register 3 paintings, 2 novels, and 5 pieces of music. It has to be 10 paintings or 10 novels.
Okay,
And you can do that under one registration, and it saves you on the cost.
let's see. Is there value in putting the C sign alongside the year if you have not yet registered your art, or is that a myth?
Prior to the 1976 Act, it was required to put the C with the year in it. That doesn't exist anymore. So is there value to it? Yes. It puts the public on notice, explicit notice that you intend this to be under copyright. The public should know that anyway, but it doesn't hurt to put that C in the year there. And especially if you have several versions of things. If you're painting a landscape once a year, every year, it might not change enough that it's easily discernible to the untrained eye. So you might want to have copyright 2021, copyright 2022 on the next painting. So it has good information there.
Is there template contracts? I think this was actually back when we were talking about
Galleries.
I'm not sure if it was This is from Dominion Works. If you want to clarify, I think that was from, let me see, I'm able to copyright them. I store also external drives. Trying to just figure out what context. But let's just talk about templates for legal things like copyrights, legal for gallery representation. Are there, good contracts rather than what is the legal
Boilerplate?
Huh?
Boilerplate?
Yeah,
Template?
I think somebody was asking about a boilerplate template as well. Let me see. And that might have also been, I think he's had some experience working in it.
Generally, the contract, though, going to be drafted up by the gallery, and then, from my...
You'd be surprised.
Oh, really?
I mean, yeah, I think if a gallery says, we want to post your art, could you please present us with a contract? That's maybe not a red flag, but a yellow flag.
Yeah.
I mean, it's certainly the gallery tipping its hand that it hasn't been in business very long,
Yeah,
and doesn't have very many resources. So I would take that piece of information and say, yeah, but I can come up with a template, but if that's the kind of hot dog stand you're running, then I want my 60%, 75%, right?
Yeah, and I guess that's what he's asking. Are there contracts that cover all of these? I guess there are
there are templates.
Zoom is what I was thinking of. LegalZoom is what the
I mean, LegalZoom is a viable option. How should I phrase this? Template contracts tend to be one size fits none. So you still have to go through it and make sure that you understand what you're contracting for, and that you understand what you're contracting for, and that it's what you want. When I was doing a continuing legal education program, I was organizing it, and to do that, you have to collect the materials of the panelists. And there has to be like 100 pages of materials before the Bar Association will let lawyers get credits for it. You have to have a certain amount of materials. And one of the panelists submitted a contract from LexisNexis, which is a big, has all the case law, statutes, contract templates, treatises. And I pointed out to her, I said, this gallery contract that is on LexisNexis that you submitted, it says that during the time that the painting is at the gallery, the copyright belongs to the gallery. And that doesn't seem right to me, but you've been doing this longer than I have. And she freaked out. So you can't always trust the boilerplate. And especially if a gallery tells you it's a boilerplate, I know from experience that professionals will copy and paste from different contracts, and it doesn't always, it turns into a sort of Frankenstein contract, and it's not always trustworthy.
Yeah. And plus, I think you kind of run the risk, especially if you don't know the law and you're making assumptions based upon the wording.
Mm-hmm.
I do know that in law, the wording, the definition of certain words carries a lot of weight, and if you don't use those definitions correctly, or you don't use those words in the correct context, that you can basically you create a liability for yourself. I mean, wouldn't you agree with that?
Yeah, I mean, there can be ambiguities. A contract is supposed to be a meeting of the minds. So what happens if the phrase is ambiguous? Typically, a contract would be interpreted against the interest of the drafter. The court's reasoning is that the drafter had control over the language. So if something's ambiguous, that's the drafter's problem. So we'll read it against the drafter's interest. So if something's ambiguous and it was given to you by the gallery, the court should read it against the gallery's interest. But yeah, and that's just the ambiguities just that happen all the time. That doesn't include terms of art, where you say, well, I thought that this legal term meant the dictionary definition. Say, no, it doesn't. I can't think of an example offhand, but
yeah. Yeah, it's just there's certain, like, Black Law's dictionary,
Yep.
may have a definition for one thing versus another. What the Webster,
Webster. Yeah.
yeah,
Yeah. I mean, that's the reason there is a Black's Law dictionary. Otherwise, we just use Webster's.
Yeah.
which could change the context of many cases at that point.
Yeah.
Yeah.
Absolutely.
We have Yvette has a question. We have about a little over 5 minutes here. Reselling your paintings, is it customary or not to receive a residual when you sell A and A to B at an astronomically inflated price?
I'm not quite sure. I mean, there's usually, in terms of resale, in Europe, there's been a resale percentage. So, right. So I think that's what she's saying. So if you sell to A for $100 and A sells to B for $150, do you get any piece of that $150? In Europe, typically, yes. In California, yes. And I think, California has sort of a way of, I mean, it's such a big market for a lot of things that it can impose, it imposes privacy laws and clothing, apparel laws, safety laws. And I think it's going to have the same effect with resale. And when I'm dealing with an NFT, I always want that resale in there. Mm-hmm. I want that artist to get that 10%, or at least we start with 10%, maybe go down to 5% if it's a hard bargain.
Yeah, that's the only thing I have really liked about NFT has been that kickback to the artist. Like I had bought a painting, back in 2015 that was valued at $1,800, and that artist has since gained in popularity to where and that was a 60 by 40 painting. I think her 11 by 14s now are selling for about $1,800. So I obviously have something there, but at the same time, it's that piece I'd never sell. It's a legacy piece in my family for now. So it's just like when that goes on to selling, with art, that there should be some compensation for the artist or the originator.
I think there's a good argument for it, and I think that's right. And that's the beauty of the NFT is if you have that in the blockchain contract, then on the resale, the artist might discover there's a resale only because he or she noticed that there's a little bit more Bitcoin in their e-wallet.
Yeah. So
it automatically goes in.
And we have several more questions that are kind of popping up, but I'll hit this one here just so we can get a little more into the photography, because that is something I always think about in kind of this chain of who owns what. If you have a celebrity who's photographed by a photographer, whose photograph later becomes, as we saw in the Warhol, a source image for art, can the celebrity say, depending on the model release, I own my image and y'all are making reproductions off selling my likeness? Does the celebrity own their likeness?
Well, probably you'd have a model release with the celebrity where the celebrity would insist, you can only use this for artistic reasons. I don't want to see this thing, advertising chamois or something like that, right? So you definitely have that restriction in there. But just your average person walking in public, that would depend on the rights of publicity law, which are state by state. Do they have rights of publicity law? Can you take it as an artwork? You can probably in most states take pictures of the public writ large and not have to get permission as long as it remains artwork and you're not using it to sell anything except the artwork. But be very careful with that, because state by state, they're going to start doing different things.
Yeah. As I said, it's a very interesting, always dynamic moving thing is copyright. I have this one. I think this is going to kind of come up to you, James. So when I send my work to Finer Works to print, I need to have contracts since they are printing my originals. We actually have something on our website too that is saying that
Yeah.
you are the owner.
Yeah, and one of the things that I do know that so a lot of color labs will be are very cautious, some more so than others, as to what they will allow people to submit for printing. Okay, and the reason being is because we as color labs, we do not want to accidentally, uh, uh, and we should not be intentionally printing works that is copyright protected. Now, in the case of an artist submitting their work or someone submitting, an image to be printed, most color labs act upon good faith, anticipating that that work is being submitted by someone with permission to have that work printed. It's and this is why we have on our terms of service that a user has to acknowledge that they have permission. Um, However, it's not something that is easily policed. Okay, and it's kind of in that area where the color labs do their most color labs that I know, including Fine Works, we do our best to try to ensure that we are only printing what we are allowed to print. But is it possible to slip one through? Again, even if we required a signed document indicating that that you have permission to have that work reprinted, okay, there's no guarantee to us that that signed document is legal in the first place. So there are some areas of that that yeah, it's kind of okay. We have to hope that the user, that the artist, the photographer is honest, but there's no way of ensuring that from our perspective.
But there's case law that, I mean, the causes of action for vicarious or contributory copyright infringement, like you saw with Napster and users of Napster, there has to be some intent. You have to have some reason to know that this is not legitimate. That said, there's no substitute for having something in writing saying that you're presenting to us that you're authorized to do this.
And I think this is a good ending question, and kind of goes into the value of copyright. What is the cost to retain the lawyer in this field? I did follow you, David, on LinkedIn too.
Yeah, I'm on LinkedIn. I'll give you the answer that my car mechanic used to give me. It costs somewhere between $1 and $1 million. But I've heard, some of the New York attorneys that I work with. Look, you get a young, hungry guy. He's charging you $2.50 an hour off of Craigslist. You get an established law firm. You're looking at $1,000, $1,100. On average, you might get 600, 400. It depends city to city, and whether it's a solo or a all service firm. It's a difficult one to answer. I don't know what they charge in San Antonio. I know that in New York, you'd be looking at about 600 to 800 an hour. In Pennsylvania, I spent a lot of time out in the Poconos, and they're charging 200 to 400, and 400 is for a specialist.
Yeah. It's like many things. It's prices and fees are really kind of almost geographical, and we're going to be pursuing a like I said earlier, a joint venture with DHF law firm, where we will be helping facilitate an affordable option for artists and photographers to protect their work. And stay tuned. That'll be, we're planning that for this, unveiling that this week in our newsletter. And this wouldn't be possible without David's help, and we definitely
thank you so much.
appreciate it. Matter of fact, this has been a great presentation, David. I want to thank you so much. We actually had quite a few more live viewers than I anticipated.
Great interaction and great questions from our audience as well.
And I suspect a lot of people will be going back and watching this for reference material. And
when this comes up on the replay, you will see, if you go ahead and click in the description, I'll have a link to David's law firm. And when James gets the copyright thing, there'll be a link also in here to get to that portion of our website as well. Yvette, thank you. Just wanted to say that Finer Works generates excellent prints compared to all the prints I've had made using different companies. Thumbs up. Thank you. And I want to thank a lot of people who've gone to our Google business page and given us those 5-star reviews. Thank you all so much. We appreciate it here.
Yeah.
And thanks for having me, you guys. And it was a great audience. These are some really insightful questions, and I appreciate it.
Great.
All
well,
right.
thank you.
David. And I'll be in touch with you just behind the scenes tomorrow. I got your message. we're good there now.
Right.
So we'll continue our discussion where we left off. And Melissa, I'll let you close.
All right. We actually have Finer Works on LinkedIn. Our company page is on there. If you'd like to follow on there as well, David. I think I have mine on there. James probably has one from, I don't know, whenever LinkedIn first started, and he probably hasn't gone back, but we do have our Finer Works LinkedIn page there. Thank y'all again so much. And we'll see y'all next month. Look on our social. If you're watching this video, make sure to give it a like and share it with any other creatives that y'all know that need this information. Have a great one. We'll see y'all next month.
Thanks, David.
Thanks, you guys. Bye.
Bye.
Bye-bye.